The honourable member for Toronto-Danforth.
Thank you very much, Mr. Speaker. So we're at report stage for Bill C-23. It's been a long odyssey to this point, one of considerable resistance to this bill on the part of the official opposition, of many sectors of Canadian society, including organizations who've engaged in the fight, academics, and so on. And also, we suspect considerable pushback from some Conservatives who themselves felt the pressure from the opposition and civil society. Mr. Speaker, it's worth recapping how we got to where we're at. In March 2012, the NDP tabled a motion that then received unanimous support, everybody in the House, to call on the government to table within 6 months, so by September 2012, a bill that would address the issue of prevention and prosecution of fraudulent election calls and would also add to the powers of Elections Canada, including, Mr. Speaker, the power of the Chief Electoral Officer to require receipts and documentation for national parties' election expenses, which, believe it or not, currently the Chief Electoral Officer does not have access to. Well, 6 months later, September 2012, a bill of that sort, focused but clearly dealing with this kind of fraud and the need to enhance the powers of Elections Canada to investigate, never appeared. By October, it was clear the government was not treating with the priority that they had promised in voting for the motion in March 2012, and so I tabled a private member's bill with a proposed, and I would say very minimal, system of a voter contact registry for dealing with fraudulent election calls, and a couple of provisions that also went to beefing up the penalties for that kind of fraud. And I told the minister at the time prior to the current minister, that this was just effectively to prod the government and also help the government to begin thinking about this, because they were clearly having trouble meeting their deadline. And I said I was available to consult as needed, and also that I expected that with the government's resources, they would be able to come up with an even more effective system. Well, by April of 2013, Mr. Speaker, we still had not seen a bill, despite any number of times I stood in this House and asked when we might. Suddenly, the former minister announced to all in a highly organized press conference on a Tuesday in April that he would be tabling the bill, the missing bill, 2 days later on a Thursday. The next day, we discovered, we heard rumors, and then on Thursday they were confirmed that this announced bill would not be tabled after all. We will never know exactly what revolt occurred in the Conservative caucus to lead to that result, but we do know there was a revolt, and we do know that that minister was then replaced by the current minister shortly thereafter. We had to wait almost a full year after that event till March of this year for the bill to finally be tabled. 2 years after the March 2012 motion, where the government had agreed that they would be tabling a bill within 6 months, and 18 months after that deadline passed. All that time was spent coming up with a bill that we have dubbed, indeed, the Unfair Elections Act, which explains why the first motion at this report stage is to delete the title of the bill, which the government has called the Fair Elections Act. We can think of no more Orwellian a title. The government has come close to titles that were equally unrepresentative of the actual contents of a bill in the past, but this one, frankly, takes the cake. So the fact of the matter is, Mr. Speaker, that the bill was tabled, and within 18 hours, as the critic for democratic reform, I had to be on my feet, having read, analyzed, and formed first views on a 242-page bill to reply to the minister at the start of second reading. Within a very short order, the House Leader was on his feet, and the House Leader gave notice of time allocation. Time allocation thereby came very quickly thereafter, and very little debate on second reading was permitted. We then went into the committee stage, Mr. Speaker, where there was an effort on the part of the official opposition, the NDP, to convince the Procedure and House Affairs Committee to allow for hearings across the country in order to hear what Canadians had to think. My colleague from Hamilton Centre put up a strong filibuster in order to convey to the government how serious we were about this, but ultimately, after 10 hours, he had to concede that the arguments had not penetrated the brick wall. We went on in through committee to have 71 witnesses, only one of which was completely in support of the bill, 1 out of 71. All the others, and most of them, were critical of large swaths of the bill, and where they were focusing only on 1 or 2 things, they were extremely critical of what it would do. That included the Chief Electoral Officer, the Commissioner for Canada Elections, the previous Chief Electoral Officer and Commissioner, the former Auditor General, Preston Manning, indeed, and the list goes on. So now we find ourselves, we found ourselves into a clause-by-clause process that ended up having an artificial end date. We had 10 hours of clause-by-clause, and by the time, Mr. Speaker, the guillotine came down at 5 o'clock last Thursday. We had got through only 1/5 of the 242-page bill in terms of pages, 1/2 of the bill in terms of the clauses, only half of the opposition amendments. And in terms of the amendments that had actually been debated, and then after the clause-by-clause that were then voted on, not a single opposition, NDP, official opposition amendment, was voted in favor of by the government. This was a total farce of a process. We looked in a constructive spirit, Mr. Speaker, at the government amendments. We voted for those that made sense. We tried to amend as it made sense. We came up with some proposals that we thought were absolutely impeccable from the government's perspective, and they still decided not to vote with us. For example, when it was clear that the government was not going to allow the Chief Electoral Officer to authorize the use of voter information cards as a second piece of identification, when it was clear that we had lost that fight, we tabled an amendment simply saying that the Chief Electoral Officer had to ensure that the voter information cards were prominently marked with the message to say that this card cannot be used for purposes of identification on voting day. Something that was designed to prevent chaos that might occur in 2015 because of the hundreds of thousands who were able to use VIX in 2011. The simplest of amendments, the most constructive of amendments, and the government took an entire night to reflect on it because the amendment was moved at 2 minutes before closing hour the day before. The government took overnight, came back and said, sorry, we can't vote for that. This was the atmosphere that we worked in, Mr. Speaker. And so now I am before you where it has to be said, the efforts of the official opposition, civil society resistance, did produce some major accomplishments in terms of this government standing down. The fundraising exemption that was criticized across the country was removed. The central poll supervisor provision that would allow the first-place parties in the last election to appoint central poll supervisors, that was also removed. Vouching for address was restored to the bill because of the pressure that we put on. Retention of documents under the voter contact registry, of some documents in any case, went from 1 year to 3 years. Public education by the Elections Canada was now permitted for students in schools, even though for everybody else it remains prohibited. We at least got on record, although the government refused to put this in text in the amendments, that the Chief Electoral Officer will be permitted to communicate freely on any subject that he wishes. These are major accomplishments, and everybody who pushed back in Canadian society on this effort, this attack on our democracy, as Sheila Fraser called it, deserves credit for that. Nonetheless, the remaining issues in the bill are huge. This bill is a bill that is much worse than the current Canada Elections Act, and as such, we will be voting against the bill and seeking as much as possible to make the few remaining amendments that are available to us as the official opposition at the report stage. Thank you so much, Mr. Speaker.
Questions and comments. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. I know that I will be afforded the opportunity to speak on the bill very shortly, but I wanted to get on the record as quickly as possible in regards to the whole issue of process. And this is something in which I think it's really important that we recognize that the bill that we have today is nothing more than a conservative piece of legislation where there was no consultation, no evidence of any form of genuine consultation that went beyond conservative members of the caucus. And even to the degree in which not all members of the Conservative caucus, from what I understand, were involved. That it's in essence being pushed out, from my best guess, the Prime Minister's office. That they call it the Fair Elections Act, but it's far from fair, given the importance of the legislation and democracy here in Canada. Would you not agree that when you change an election law, that it should be based on consensus and professional advice should have been sought from organizations such as Elections Canada?
Well, member for Toronto-Danforth.
Thank you, Mr. Speaker. Mr. Speaker, I would actually like to decline to answer a question on the fairness of democratic process from that member, considering the role the Liberal Party is currently playing in completely undermining all fair process in the Board of Internal Economy and the Procedure and House Affairs Committee. Thank you.
Questions and comments. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. As time ticks down, I think this may be my only chance to speak this bill at report stage. I want to thank the honourable member for Toronto-Danforth and the official opposition for standing so clearly with the rights of smaller parties and independents and our ability to speak at report stage and submit substantive amendments when those rights were not respected through the committee process through no fault of our own. My question to this member is, what can we do as parliamentarians who love this place, love Westminster parliamentary democracy, as we watch it consistently reduced, stomped upon, abused, and held in contempt? At what point do we find our way to drive the point home that we are losing democracy in this country?
Well, member for Toronto-Danforth.
Thank you, Mr. Speaker, and I share and appreciate the passion of the member for Saanich Gulf Islands on this point. I think it's incumbent on all of us not to allow the Canadian public to forget what this bill is all about and what the struggle to at least make it less terrible than it started was all about over the next year. Indeed, we cannot afford to have another government in power that acts in the way this government does. And I would have to say that apart from reminding Canadians of what the vote will mean in 2015, Canadians also have to join with the NDP and the Green Party in making sure we change the electoral system to a system that embraces proportional representation. So this kind of government that's elected with less than 40% of the vote and gets more than 50% of the seats can never again do what it's doing to this institution.
Nous avons le temps pour un bref.
Time for one brief question and answer. The member for Louis Saint Laurent. Thank you very much, Mr. Speaker, and I really want to thank my colleague who's worked so hard on this issue. In committee, I had the opportunity to study the bill with him, and I would like for him to quickly give us an overview of all of the things that are still missing in this bill. For example, I know that we didn't have the opportunity at committee to debate the sections and amendments that concern the Commissioner of Elections, who is the investigator for these issues. And we know that there are several things lacking in terms of the powers given to the Commissioner. So if you could address that and talk to us a little bit more about the other things that are lacking in this bill. Thank you.
Thank my colleague whose work I deeply appreciate and with whom it's always a pleasure to work. I will answer in English in order to make this as specific as possible. It is indeed the case that the Commissioner for Canada Elections is transferred over to the Attorney General's office under the Director of Public Prosecution. We had no chance to debate that. We had no chance to debate the issue that that person is now dismissible for cause by the Director of Public Prosecution. The fact that the voter information cards remain banned is something that we did not succeed on. The fact that the Chief Electoral Officer cannot have access to party receipts for campaigns, the fact that the judicial orders to compel witnesses to cooperate in investigations was also not something that has been changed. The fact that public education broadly beyond students in schools remains banned. The fact that audio recordings and scripts do not have to be conveyed to the CRTC, and phone numbers not only don't have to be conveyed to the CRTC, but don't even have to be kept. These are just a few of the problems that remain in this bill. Thank you, Mr. Speaker.